So good afternoon, everybody. I'm Simon Cox, and I'm joining you remotely from Doughty Street Chambers, so to speak. We're just letting people fill into the webinar. I think we have something like a couple of hundred people joining us today, and so it takes a little while for people to join in Zoom. So if you are just joining, I'm just talking at the moment, just to fill the gap while other people enter the Zoom seminar. And then when enough people have entered, we will start with the seminar proper. So that looks like we have all the people who were in the waiting room have come in. As I've already mentioned, my name is Simon Cox. I'm a barrister at Doughty Street Chambers in the immigration team. Welcome to this Doughty Street Chambers seminar. If you didn't hear the beginning of my talk, don't worry, you haven't missed anything yet, and there will be people joining as I go on. So I'm joined today by 5 of my colleagues in the immigration team, including 2 tenants who joined us during 2020. So we're joined by, first speaker will be Antonia Vaughan, and he will be sharing with you some highlights from 2020 relating to international protection and Article 3 of the ECHR. As you can see on the screen, we'll then be joined by my colleague Alasdair Mackenzie, who will be dealing with some interesting cases on procedure. Our new colleague, another colleague who has joined us in 2020, like Anthony has, Camila Zapata Besso, who will be talking about the Court of Appeals judgment on undue harshness. Then Zoe Harper, who will be dealing with developments in trafficking law. And lastly, Antonia Benfield, who will be talking about children's rights. Now, each of the speakers is on a strict time limit, and I'll stop talking very shortly to allow us for questions at the end of the seminar. But in order for the panelists to have the best chance of giving you a considered question, please do, if you can, post your question as soon as possible into the Q&A function that is on the page. Please use the Q&A function for questions. I'm only going to be looking at the Q&A function for your questions, but we also, because there's a lot of wisdom on the call, 118 participants at the moment, immigration practitioners of all kinds of specialisms, put things into the chat. If you have ideas or comments for colleagues, then feel free to make the chat a place where you share those. But as I say, if you have a question, please post it as soon as possible into the Q&A so that we can consider which questions we'll be able to ask in the time available at the end. As is normal, your videos are switched off and you are muted. So the only way of communicating with us really is through Q&A. That's the end of my opening presentation. And I will turn over to Antonia Vaughan to talk about international protection and Article 3 of the European Convention on Human Rights. Anthony.
Thanks very much, Simon. Anyone who has run Article 3 medical cases in the last 15 years knows how difficult they are to win and how emotionally draining they are to conduct. And until last year, people suffering from a terminal illness who would not have access to the medical treatment they need on return to their country of origin could not win an Article 3 case unless their death was imminent. Now, as we know, that threshold was virtually impossible to meet, and that was the effect of the test of the House of Lords set down in the case of N, which was upheld by Strasbourg in N in the UK. And that test clearly had inhuman consequences and did throughout the currency of the time that it applied. But what happened last year is that the Supreme Court swept away that approach in the case of AM Zimbabwe and has set out an entirely new one. So I'm just going to make 3 brief points about AM. Next slide, please. Can we just can we go back 1 slide, please? Yeah, there we are. Okay, so the first point is that it abolishes the N threshold. And it did this by applying the 2016 Strasbourg case called Paposhvili in Belgium, where the court clarified its approach to the N case. And I've set out the test there in the slide. So on account of an absence of appropriate treatment or the lack of it, that removal would expose the person to a serious, rapid and irreversible decline in their health, resulting in intense suffering or a significant reduction in life expectancy. Now, that is quite clearly a less restrictive test than the deathbed test as it was known in N. And the Supreme Court applied this test from Paposhvili and overruled the Court of Appeal, which said the test meant something completely different. And in doing so, the court made clear that Strasbourg had changed its mind about M. And that's an important point because M has been swept away by these judgments. The second point I want to make about AM is that it sets out a range of new procedural requirements, or at least new from the perspective of the Supreme Court and the domestic approach. Next slide, please. And I've set out what is paragraph 23 of Lord Wilson's judgment, in which he sets out these elements. And I've put in bold text essentially what those are. So the first is that the applicant still retains the burden of proving their case, but only needs to prove a prima facie case, meaning they have to prove that, taken at its highest, there would be a violation of Article 3. Now, having done that, the burden then switches over to the respondent, who has to show that any doubts about that case are dispelled. And C, D, and E from paragraph 23 of the judgment sets out more detail about how the state should go about dispelling those doubts. So the requirement in C for verification of the general availability of sufficient treatment. We often saw generalized evidence from the Home Office about what general medical arrangements there were in the country of return. But D, which is really important, we need verification that treatment is available to the appellant in practice. Now, this requires much more than simply producing evidence of the general availability of treatment. There needs to be findings about and there needs to be evidence that the particular individual in their particular circumstances, for example, having regard to cost, geography, family network, whether they would be able to access treatment in practice. And then if there remain doubts, the court makes clear that you would need an individual assurance to make sure that the treatment is available and accessible, which means a specific statement from the country of return that they would be able to provide access to that specific treatment in the specific case. So these are important requirements that make an Article 3 case viable where one perhaps wasn't before. Next slide, please. So the third point to make about AM is simply that we may have to, it will affect existing case law, it's likely to affect existing case law on other areas involving Article 3 and expulsion. So I've referred there, for example, to the situation of poor humanitarian conditions in the country of origin. So Said was a case where the Court of Appeal said that even if you're being sent back and you had a mental health problem, and the court said, let me just read this part of the judgment. So where you have a removal on the grounds of destitution on return, which are not the responsibility of the receiving country or others in the sense described in Sufi and Elmi, whether or not the feared deprivation is contributed to by a medical condition, the person liable to deportation must show circumstances which bring him within the approach of the Strasbourg court in D and N. Now, in the light of AM, that clearly will need to be revisited. Another example is where you have situations of state responsibility in the sense of MS, Belgium and Greece, should the test be amended there? If it was amended for N, does it affect the exception? Another issue is whether or not a serious deterioration in mental health amounts to intense suffering in the sense described in AM. Probably does, but there's an argument there as well. And it also remains a moot point whether the procedural requirements I've explained apply to non-medical Article 3 expulsion cases. Next slide, please. So DH is an important case on the membership, on what membership of a particular social group is or how it's defined for the purposes of the Refugee Convention. So I've put in this slide Regulation 6D1, Regulation 6D of the 2006 regulations, which seem to contain a definition of PSG. And that first limb is dealing with what is essentially a protected characteristics approach. And the second looks to social perception. Now, the story of DH is essentially that in the House of Lords, in a case called Fauna and Kay, the majority took the view that these criteria were alternatives. So you didn't have to meet both of them in order to make good your case on a particular social group. You just had to show that you were one or the other, essentially. The problem that then occurred is that the upper tribunal, as often it has done, decides that the House of Lords' view on the point was not binding and proceeded to rule themselves in a number of cases that you had to satisfy both 1 and 2 before you could make good your PSG argument. So to cut a long story short, in DH, the upper tribunal said, okay, yes, the House of Lords in Fauna and Kay, we are going to follow that. These criteria in Regulation 6D are alternatives. So this applies to any case involving the existence of a particular social group. And I've set out there in the second bullet point, the alternative criteria in the case of mental health. Next slide, please. So just lastly, 2 brief references to other notable cases from 2020. The first is MN, a case in which Xu Xin Lu of these chambers appeared. So as Zoe may go on to refer to, I don't know if you are or not, but it's principally about support for victims of trafficking, but it's worth a read about what it says to the approach to expert evidence in assessing credibility. And the other is NF Kenya, which involved a student who downloaded extremist material. And this relates to the threshold for exclusion under Article 1 FC of the Convention. But I see I'm out of time, so I'm going to stop and hand over to Alasdair, who is going to talk about some procedural developments from last year.
Thank you very much, Anthony. I hope you can all hear me. There's a couple of things that I want to talk to you about. One is fee waivers and the other is oral hearings. And I've posted in the chat a link to some notes, which you may find it helpful to have open while I'm speaking, and you may find it helpful to look at when I've finished, because I will have to go through these quite quickly. So fee waivers. In May, the upper tribunal decided in the case of Daneku Ligason, which you've got the reference for there, that the Home Office's fee waiver policy for in-country human rights claims was unlawful. And the tribunal's rather emaciated headnote doesn't really do justice, I think, to the breadth and importance of the judgment. Next slide, please. First of all, it decides that the previous fee waiver policy was wrong to apply a test of destitution. The policy said that the Home Office would only grant you a fee waiver for an in-country human rights claim where A, you were already destitute, B, you were at risk of becoming destitute if you paid the fee, or C, there were exceptional circumstances. But the exceptional circumstances test didn't add very much because it simply pointed back to the same test of destitution. In fact, the previous case law said that you had to be granted a fee waiver if you couldn't afford the fee. Now, obviously, there's a difference between someone being destitute, that is to say, without accommodation, without the means to meet their essential living needs, and being unable to pay a fee. And the fee in this case, it was 2 parents and 3 children, amounted to £7,665 at that time, including the NHS surcharge. But they were being accommodated, the family, by a family friend, and they were being given food and so on by their church and by their friends. So they weren't destitute, they weren't on the streets, they weren't short of food, they weren't at risk of becoming destitute either, because even if they did somehow manage to scrape together £7,500, that wouldn't jeopardize their accommodation. But as a result of that policy, they couldn't even apply to regularize their status, even though they clearly had a strong case prima facie under the 7-year rule, as the 2 older children had been born in the UK and had lived here for over 7 years, in fact, well over 9 years, if I recall rightly. Next slide, please. And the Home Office's argument when challenged was essentially to say, yes, we agree the correct test is affordability. Could the applicants afford the fee? But she claimed that that was what the policy actually said. Next slide, please. And if you've read that policy or you've ever had to apply for a fee waiver, you might find that pretty hard to agree with, and so did the tribunal. It was pointed out to the tribunal that the policy used the term destitute or destitution something like 40 times. Now, why would it do that if that wasn't the correct test? And how was that not liable to lead the Secretary of State's caseworker to ask the wrong question? And the tribunal basically agrees that the policy didn't apply the test, which the Secretary of State accepted to be the correct test, because it fails to focus the mind of the reasonable and literate reader, these are the tribunal's words, on the affordability test. The reader would understand something more than affordability to be required. What then of ability to borrow money, which the Secretary of State included as part of the policy and often, as people will be aware, uses as a reason to refuse a fee waiver? Well, the judge is even more scathing about this aspect of the policy. He does say that in some instances a person might be able to borrow from their bank, which might or might not be reasonable in some circumstances, but that wasn't this situation. We're talking about a family who have been given a place to sleep and food to put in their mouths through the charity of their friends, who in the real world is going to lend them £7,500. And the judge points out, paragraph 95, that people can't possibly prove that they can't borrow from anyone at all in the entire universe. I paraphrase slightly. But he says in his own words at paragraph 96 that this whole argument has an air of fiction. He says there's no reason to think that individuals in the position of these applicants might have access to one or more Dickensian benefactors who would be able and willing to provide a loan of nearly £8,000, which might never be repaid. Next slide, please. In response, the Secretary of State has amended her fee waiver policy, although it must be said that the amended policy doesn't meet all the tribunal's criticisms. It starts by confirming that a fee waiver may be granted if the applicant is not able to pay the fee, but then it goes on to repeat at some length the destitution test, which has been found to be unlawful. It does take out the reference to borrowing, and as far as I'm aware, the application form still requires you to show that you're destitute or at risk of becoming destitute. So there's still a way to go before the Secretary of State acts lawfully. But there's another important aspect of sine qua litigation which has been overlooked, which is that the Secretary of State conceded during the proceedings that it wasn't necessary to pay a fee at all for a human rights claim, never mind whether you can afford it or not. And during the hearing itself, Home Office counsel handed up a note which confirmed essentially that you don't. And the official head note to the judgment, you might think extraordinarily, doesn't mention this at all, nor does the Secretary of State's amended policy reflect it. Now, most of the Home Office's note is reproduced by the tribunal at paragraph 71, and the full text is in the handout. Next slide, please. But in summary, what it means is this. First of all, a letter raising private and or family life in the UK can, in itself, just a letter, constitute a human rights claim. Secondly, even if no fee is paid and no fee waiver has been granted and no form used, it's still a human rights claim. Next slide, please. Thirdly, that claim has to be considered by the Home Office. They can't simply ignore it. And fourthly, the only advantage to paying the fee, or as the case may be qualifying for a fee waiver, would be a procedural advantage, i.e. the case might be considered more quickly. And on the facts of the case, the tribunal judge doesn't find this to be a satisfactory defence, if only because the applicants hadn't been told this. On the contrary, what they had been told is that they hadn't made a valid human rights claim and that they were going to be removed. So entirely different from what the Secretary of State said to the court. Again, there's no sign that the Secretary of State has put that into practice, and the exact ramifications of that concession remain to be seen. Finally, on this point, I'd just draw your attention to the fact that the entry clearance fee waiver policy, which is a separate policy, seems to be totally out of line with what the Secretary of State conceded in sine qua litigation, both as regards the need to pay a fee at all for a human rights claim and as regards the destitution test. Not only do you have to show destitution, but you also have to show that the destitution is as a result of exceptional circumstances, and exceptional circumstances are very narrowly drawn so as to cover matters such as civil unrest or natural disaster. Seems to me, on the face of it, at least completely unlawful, and there are a number of challenges to that policy on foot at the moment. So keep your eye open for that. Next slide, please. And the next case I want to look at is JCWI and the President of the Tribunal, which was decided in the Administrative Court in November. Next slide, please. Now, this arose from guidance issued at the start of lockdown by the upper tribunal, which said that certain decisions would usually be made on the papers without an oral hearing, and specifically that related to error of law decisions only. And the tribunal was required by the policy to take account of the parties' views on whether there should be an oral hearing of that question, the error of law question, obviously a remote hearing, but only if it had already reached a provisional view that there should not be a hearing. And the guidance implied that the tribunal would only decide to hold a hearing where oral evidence and all findings of fact were needed to determine whether there had been an error of law. Or alternatively, whether there were particularly complex or novel or important issues of law. A number of objections were raised to this, but the tribunal stood firm, and it fell to the JCWI to bring a JR, which it did with the support of evidence from a large number of practitioners. And the whole thing basically turned out to be something of an embarrassment for the tribunal. For a start, the guidance is quashed, and I've given you more detailed summary reasons in the handout. But Mr. Justice Fordham basically says that the tribunal has misunderstood the senior president's practice direction, which was supposed to be the enabling instrument, and had discounted the importance of the overriding objective and the requirements of fairness. And he goes on to give a strong endorsement of the importance of an oral hearing at which the judge can listen to and engage with the rival arguments on grounds that this is fairer, that decision-making is likely to be improved, and that there's a need for respect for the people concerned and the significance of the case for their future, which were all matters which the tribunal had basically discounted in favour of its own administrative convenience, that is to say, not having an enormous backlog of cases building up. And to make matters worse, the tribunal seems to have shifted its rationale for the guidance over the course of time. In correspondence with the Bar Council, it initially said that the guidance did point to routinely dispensing with oral hearings and said that that was lawful. Before the court, possibly having received robust advice, who knows, it accepted that it wasn't lawful to routinely dispense with oral hearings, but it said that the guidance didn't say that. The difficulty being that, first of all, that was exactly the opposite of the position it started with, and secondly, the guidance said in terms that decisions should usually be made without a hearing. I just need another 20 seconds. So the tribunal was arguing that its guidance didn't mean what it said on its face. And the court didn't accept that. It gave the tribunal a helpful lesson in the importance of an oral hearing before ordering it to notify people adversely affected by its misunderstanding of the basic rules of fairness. So it was all a bit of a humiliation for a tribunal which is supposed to guarantee people's fundamental rights. As far as I can see, there's been no further guidance to replace the quashed guidance. Thank you for your questions, which I'll come on to. I'm going to hand on to Camila next.
Thanks all. I'll be talking about the Court of Appeal's welcome guidance on the unduly harsh test as is specifically relevant to children of proposed deportees. Next slide. As many of us will know, Section 117A to D of Part 5 of the Nationality, Immigration and Asylum Act 2002 puts on a statutory footing what the public interest requires the court to have regard to in deportation and removal cases where the court is considering proportionality under Article 8 of the European Convention on Human Rights. It sets out a number of exceptions to the general proposition in Section 117C(1) that the deportation of foreign criminals is in the public interest. Exception 2 is applicable to children under Section 117C subsection 5 is where C has a genuine and subsisting relationship with a qualifying child, which is either a British citizen child or a child who has lived in the UK for a continuous period of 7 years, and the effect of C's deportation on the child would be unduly harsh. Next slide. By way of a refresher, in KO Nigeria, the UK Supreme Court looked at whether, when considering what unduly harsh means, parental misconduct is relevant. The answer from the Supreme Court was no. The focus was on the child only. Why? Well, the public interest is already built into the statute, as was made clear by the court at paragraphs 12 to 23 of its judgment. Importantly, per Lord Carnwath at 23, the unduly harsh test should not become too high a threshold. The Supreme Court approved the test in MK Sierra Leone and the Secretary of State of the Home Department 2015 in the upper tribunal, that the test was not uncomfortable, inconvenient, undesirable, or merely difficult. It was a considerably more elevated threshold. The addition of the verb unduly raised an elevated standard higher. but it was plainly less stringent than very compelling circumstances. Next slide. Now, turning to the Court of Appeal's 2020 judgment, first is HA Iraq. In that case, both appellants were Iraqi nationals in settled relationships with women of British nationality and were parents to young British children. The first tier tribunal allowed both appeals, but the Secretary of State appealed. In HA's case, the UT had judged that HA's relationship with his children was particularly close and described him as a very much hands-on father who was the primary and constant carer of his children. His children would not be able to visit him in Iraq. However, the upper tribunal found that his deportation would not be unduly harsh because there was no evidence that its effect on his children and partner would be anything other than that which was ordinarily to be expected by the deportation of a partner or parent. In the Court of Appeal, Lord Justice Underhill clarified the meaning of unduly harsh from paragraph 39 onwards, as touched on in KO Nigeria 23, observing that Lord Carnwath's focus in that case was not primarily on how to define the threshold, and his statement that the degree of harshness will go beyond what would necessarily be involved for any child faced with the deportation of a parent should not be read literally. Lord Justice Underhill stated, "It is hard to see how one would define the level of harshness that would necessarily be suffered by any child. Indeed, one can imagine unusual cases where the deportation of a parent would not be harsh for the child at all, even where there was a genuine and subsisting relationship. The underlying concept is clearly of an enhanced degree of harshness sufficient to outweigh the public interest in the deportation of foreign criminals in the medium offender category." Next slide. However, Lord Justice Underhill stated, whilst recognising the elevated nature of the statutory test, the statutory intention is evidently that the hurdle representing the unacceptable impact on a partner or child should be set somewhere between the low level applying in the case of persons who are liable to ordinary immigration removal and the very high level applying to serious offenders. Next slide. Importantly, there is no reason in principle why cases of undue harshness may not occur quite commonly. How a child will be affected by a parent's deportation will depend on an almost infinitely variable range of circumstances, and it is not possible to identify a baseline of seriousness. The Court of Appeal held that the upper tribunal had proceeded on the basis that it was sufficient to say that the situation in HA's case was of a kind which is commonly encountered in deportation cases. That was the wrong approach. The court also recognised the importance of taking into account evidence of emotional harm caused to children as the result of deportation, and guarded against the pitfalls of regarding physical harm as intrinsically more significant than physical harm, per Lord Justice Peter Jackson at paragraphs 156 and 159 of the judgment. It should be noted that the Court of Appeal in HA rejected HA's arguments that both the stay and go scenarios in paragraph 399A of the immigration rules must be considered mutually exclusively. In other words, that the fact that it would be unduly harsh for HA's children to relocate to Iraq meant that he could not be deported, leaving them behind, even though the separation would not involve any unduly harsh effect if the children remained in the UK. The argument was held to be plainly ill-founded and contrary to the wording and purpose of the statute. Regarding the second appellant in that case, RA, the court recognised that in making the decision on the go scenario that the relocation of RA's daughter to Iraq would be contrary to her best interests, the upper tribunal had not provided sufficient reasons bearing in mind the importance of her citizenship, as underscored by Lady Hale in ZH Tanzania of 2011, and country guidance on difficulties faced by returnees. The upper tribunal had also failed to give any indication of the kind of role RA had played in his daughter's life, from which it would have been possible to make a proper assessment of the degree of harshness that his deportation would entail. Next slide. Next, I turn to AA Nigeria. The first tier tribunal had allowed AA's appeal on the basis that his deportation would be unduly harsh on his children. However, on appeal, the upper tribunal overturned this aspect of the decision. The Court of Appeal reiterated the guidance in HA regarding the unduly harsh test, emphasising at paragraph 12 that it is not possible to identify a baseline of ordinariness. Lord Justice Popwell cautioned at paragraph 41 of the judgment that this appeared to be a case in which the upper tribunal had interfered merely on the grounds that its members would themselves have reached a different conclusion. This was impermissible. The decision of the first tier tribunal was restored, allowing AA's deportation appeal. Next slide. Last, I turn to KB Jamaica. KB had 4 British citizen children with whom he had a genuine and subsisting relationship that had separated from the mother. There was expert evidence that his deportation would cause significant trauma to his children, for whom he was a good role model, whose presence was essential to the functioning of the family. In a decision which predated KO Nigeria of 2018, the first tier tribunal allowed the deport appeal on the basis that it would be unduly harsh on his children. However, the Secretary of State's appeal to the upper tribunal was successful. The question for the Court of Appeal was again the nature and level of the evidential threshold which must be met to satisfy the unduly harsh test. The Court of Appeal reiterated the principles in KO Nigeria and the unduly harsh test as clarified in HA Iraq and AA Nigeria, and assimilated these at paragraph 15 of the judgment. I've not set these out in my slides, but I recommend that any practitioner preparing an appeal on this basis has regard to the Court of Appeal's summary of the relevant principles as set out at paragraph 15 of KB and cites them in representation. The Court of Appeal found that the upper tribunal's decision to overturn the first tier tribunal's finding on the unduly harsh question was erroneous. The court was clear that it is not the case that the upper tribunal is entitled to remake the decision of the FTT simply because it does not agree with it or because it thinks it can produce a better one, per the upper tribunal in UT Sri Lanka. I apologise, the Court of Appeal in UT Sri Lanka. Next slide. Lastly, I would ask that all be aware of the 2019 Court of Appeal judgments, which were not disturbed by the Court of Appeal in HA Iraq. The time constraints in this presentation don't permit me to go through the facts of each, but I only caution that in JG Jamaica of 2019, a very high detrimental effect on the psychological well-being of children was found to meet the unduly harsh test, whereas in PG Jamaica, a father of 6, although on the face of it, there were compelling aspects to the relationship between him and one of his children, this was found not to meet the unduly harsh test. Practitioners should be aware of these judgments, but remember the enjoinder of Lord Justice Underhill that how a child will be affected by a parent's deportation will depend upon an almost infinitely variable range of circumstances, meaning none of these cases should be treated as a touchstone, and a holistic assessment is still required based on the facts of your particular case. As always, expert evidence seems essential to meet the threshold. This means country expert evidence on education, children's rights, parents' employment, discrimination and place of removal, school reports from the UK, an independent social worker report, and psychiatric reports as regards the effect on a child or indeed a partner remaining in the UK. That concludes my presentation. Last of all, feel free to contact me with anything arising.
I'm going to be speaking about trafficking developments over the last year. Next slide, please. Those practicing regularly in representing victims of trafficking will be aware that the Secretary of State has finally published its guidance, its statutory guidance under Section 49 of the Modern Slavery Act 2005. It's in a different part of the Home Office website, so it needs some hunting down. It replaces the competent authority guidance and the frontline staff guidance on identification that we were all very familiar with, but replicates a lot of it in its new guidance. The Home Office guidance on discretionary leave for victims of trafficking continues to be in a separate document in the immigration section of the website. Decision-making in accordance with the trafficking policy remains very poor and challengeable under judicial review. And also the policy still contains gaps in terms of its compliance with the obligations under the Council of Europe action on victims of trafficking. And where there are gaps, the policy itself will be judiciable by judicial review, as was identified in PK Ghana some time ago, but since confirmed in MS Pakistan and later cases. Next slide, please. The case of MN that Anthony referred to considered decision-making by the Home Office, a competent authority in terms of decision-making on whether a victim of trafficking is conclusively identified as such by the competent authority. It considered the assessment of credibility by the competent authority and the role of expert evidence in the conclusive grounds decision identifying a victim of trafficking. It has a lot to say on expert evidence and the assessment of credibility, and this is a decision that I would recommend reading in full. And I would echo Tony's comments that it's worth refugee practitioners who don't represent in trafficking cases also considering this case, because the judge goes through the case law on the use of medical expert evidence and expert evidence more generally in some detail, and provides some analysis of those cases, and that will be relevant to instructing experts and also in considering their reports before finalising. It makes some helpful comments on the weight and relevance of expert evidence in relation to trafficking decisions, particularly in the context where trafficking decisions in conclusive grounds decisions are made generally on the papers, but that the analysis of the case law guidance will also be relevant to cases more generally, even where applicants and asylum seekers have been interviewed. In short, it has relevance more generally. In particular, there is a considerable discussion on medical opinions given on the consistency of findings with an individual's account, which without more would be considered to be neutral as to the truthfulness of that account. But the guidance does discuss that it's permissible and in fact in trafficking cases helpful for the doctor to express an opinion on their findings being supportive of the truthfulness of an account. But one thing to consider in particular is the importance of doctors who do that considering alternative causation for the physical or psychological injuries incurred, because this will affect the weight to be given to the report, even though the Court of Appeal was very clear that a report cannot be dismissed altogether where alternative causation is not considered. And that is relevant in terms of instructing medical practitioners in considering causation when giving their opinion and alternative causation. The case also comments on the use of evidence by trafficking experts who might be considering the correspondence of an account with other reported trafficking cases, and finds that this may be taken into account, but it's treated slightly differently to the consistency opinion given perhaps by a medical expert commenting on the consistency of symptoms with an account. And it will be necessary to consider the weight and value of the report in the individual case, and particularly considering the degree of correspondence between the victim's account and other accounts, and being mindful of the possibility that an applicant may be repeating a story having been coached to do so. The judgment is also very critical of the Secretary of State's approach to inconsistencies in the decision, finding in some parts that it demonstrated a hypercritical mindset, actively looking for reasons to discount a claim when relying on small inconsistencies. And again, the analysis in what's quite a long judgment will be helpful. Next slide, please. The big case of the year was MS Pakistan before the Supreme Court, following valiant efforts of the Anti-Trafficking Labour and Exploitation Unit in holding their nerve and bringing this case all the way to the Supreme Court. The Supreme Court resolved the issue of the tribunal's jurisdiction to make findings of fact on trafficking where there has been a negative conclusive grounds decision within the NRM. It's determined for once and for all that it is for the tribunal to make its own findings of fact, and where there is a negative conclusive grounds decision, it's not necessary to challenge that on public law grounds. It is for the tribunal to make its own findings on fact on past history of trafficking in order to assess the matters before the tribunal, which will generally include the future risk to the appellant. Of course, the proper consideration and weight to be given to the NRM decision will depend upon the nature of the previous decision in question and its relevance to the issue before the tribunal, as stated in the UK Supreme Court. In practice, where there's been a negative conclusive grounds decisions, there may well be reasons why the first tier tribunal will be in a better position than the competent authority in determining whether trafficking has taken place. There may well be new information, there may well be new expert evidence, and they will often have the opportunity to hear live evidence. And so there is scope, therefore, in making their own findings on trafficking to identify a person as a victim of trafficking. Also, where there's been a positive conclusive grounds decision, again, taking that into account, this would amount to a concession that the applicant's telling the truth about past history of trafficking, and I'd argue that the tribunal shouldn't go behind. The Supreme Court also considered the question of whether a removal in the case of MS following a flawed NRM decision would breach the positive obligations of Article 4 ECHR. He was found not to be at risk of re-trafficking, but the question was, could his removal be prevented because the positive obligations under Article 4 had been breached? There are positive obligations in terms of the comprehensive approach required to protect victims of trafficking, including procedural obligations to investigate potential trafficking situations and measures to protect victims in certain circumstances. There was a question as to the extent to which the Council of Europe Convention informs the provisions under Article 4 ECHR, which the Supreme Court sidestepped, but found on the facts in MS's case that because he had lacked the opportunity to have his case investigated by the police and his removal would prevent that from happening, then there would be a breach of the positive obligation there. Also last year, the European Court of Human Rights issued its first Grand Chamber judgment on trafficking, which further considers the interplay between the Council of Europe Convention and Article 4 ECHR. It synthesizes, considers and expands some of the discussions around the analysis of trafficking from chamber judgments that have gone before. Next slide, please. In terms of determining refugee status for victims of trafficking who claim asylum, again, echoing Tony's analysis of the importance of this decision, on the definition of a particular social group. It has particular relevance for victims of trafficking because it differs from the approach that had previously been adopted in the trafficking country guidance cases of SP and AZ, which we've consistently argued are incorrect because they don't follow the line discussed in fauna and accepted by UNHCR in its definition of a particular social group. Next slide, please. There remain ongoing problems with decision-making on discretionary leave and also considerable delays. We're still seeing blanket refusals of discretionary leave to remain while people have asylum decisions and asylum appeals pending. And this was found to be unlawful in 2019 and is still unlawful and therefore challengeable. But one of the considerable problems in recent times is that the broken nature of the decision-making system, there are simply huge delays in determining the identification of victims of trafficking on conclusive grounds, as on average 15 months, but in many cases far higher. In light of this, there have been some useful challenges which have taken this context in order to press for either discretionary leave to remain or the right to work to be granted at an earlier stage, and it gives an indication of some of the creative consideration of how to remedy this situation in a context where the threshold for challenging the delay itself it is very high. There are two decisions there, EOG, which considered somebody who wasn't in the asylum process and didn't have leave between the period of reasonable grounds and positive conclusive grounds, because their leave, which was based on a temporary work limited leave, was due to expire, and it was found that it was unlawful to leave that person without leave, and that the Secretary of State had to come up with a policy to fill those gaps. A similar type of challenge was brought by an asylum applicant who again had huge delays with from their reasonable grounds decision, waiting for a conclusive grounds decision challenging the permission to work policy for asylum seekers and its restriction to shortage occupations. And here the policy was found to be unlawful because it failed to make clear the discretion that decision makers have to consider the individual facts of a person's case. But unfortunately, IJ's individual challenge failed because the Secretary of State was found to have in fact given individual consideration to his case. Next slide, please. Looking at future gazing for 2021, many of the concerns remain that we've been battling through the last year will continue into 2021, and perhaps heightened by the context of the pandemic. One thing particularly to look out for will be trafficked EEA nationals in the context of Brexit, where the provisions are looking likely to cause quite a mess for victims of trafficking, and will perhaps be an area of development in the next year. Next slide, please. And finally, some excellent guidance, but just not from the Home Office. I wanted to finish by flagging up what I found to be a really helpful, a really comprehensive practitioner resource, a 700-page plus analysis of huge areas of law affecting victims of trafficking, including a very detailed consideration of the trafficking determination process, international protection claims for victims of trafficking, but also the kind of wider protective elements around the criminal process and appeals processes for where victims have convictions. And so I would really recommend it as a very, very helpful resource for those who are representing victims of trafficking in the process. And that's all from me.
Thank you, Zoe. I'm going to conclude by dealing with 5 cases that deal in general with children's rights in the immigration context that are quite varied in nature, but show interesting approaches into some important facets of where children are affected in the process. So the first case was the start of 2020, the Upper Tribunal considering the relevance of British citizenship in an application for entry clearance made by a parent under Appendix FM. So in short, mother was a Sri Lankan national who'd met her British national husband in Sri Lanka. They had 2 children who were joint British Sri Lankan nationals. And the question of dual nationality, as we'll come on to, was a relevant factor in the Upper Tribunal's assessment. And in short, they had made applications for entry clearance for the mother, which were refused repeatedly on the basis of the financial requirement not being met. And also on the basis that it was deemed there were no exceptional circumstances. It was accepted by SD on appeal that the financial requirement wasn't met, but their argument, in short, was one of proportionality, stating that the refusal of entry clearance effectively prevented the 2 children from living in the UK. That engaged Article 8, they said, on the basis that nationality and citizenship were an important aspect of social identity. They said that the decision in practical terms robbed them of their opportunity of their rights as British citizens, both in terms of their right of abode and its concomitant rights, so education, NHS treatment, social relationships, etc. They raised, not by analogy, but referenced section 117B6 of the 2002 Act, in suggesting that British citizen children who were overseas, effectively when their parent hadn't entered, for example, the UK unlawfully, shouldn't be in a worse position on the basis that they were applying for entry clearance rather than, for example, overstaying. The Secretary of State's position really was that Article 8 wasn't engaged. They said that further application could be made when the rules were met. The question of interference of Article 8, essentially Secretary of State saying it wasn't of such severity to engage Article 8, was unhesitatingly rejected by the tribunal. We see that at paragraph 84 of the judgment. But the first tier went on to refuse, dismiss the appeal. That was then set aside for legal error, namely the failure to take account of the British nationality of the children before it came before the Upper Tribunal. Could I have the next slide, please? So this is the head note of the judgment, short and to the point, essentially that British citizenship is a relevant factor when assessing the best interests of a child, and includes the opportunities for children to live in the UK, receive free education, healthcare, welfare provision. The tribunal held that there's no equivalent to section 117B6 in the provision of law or policy in relation to entry clearance, then considered that in assessing whether the refusal to grant a parent entry clearance to join their partner had unjustifiably harsh consequences, the fact that a parent has a child living with him or her who is British was relevant, but not necessarily a powerful factor. So when assessing the significance to be attached to the parent's child having British nationality, it was also relevant to consider that the child possesses dual nationality and what rights and benefits flow from that. The next slide, please. So some other interesting observations. The panel in the Upper Tribunal found that relevant Strasbourg jurisprudence on Article 8 recorded that nationality was relevant and should be considered, but didn't find any support in the jurisprudence for it amounting to powerful reasons for granting admission, or that substantial weight should be placed upon a child's nationality. The tribunal went on to consider that a British citizen child can require the Secretary of State to have regard to their nationality, but nothing really went beyond that. The case was an interesting one because the tribunal ultimately held that there would be difficulties for the sponsor moving to Sri Lanka, but didn't consider that those posed insurmountable obstacles or unjustifiably harsh consequences. And that was notwithstanding a best interest assessment of the children, finding that it was highly likely that their welfare would be diminished by not having their father live with them, and that prolonged separation of the family would have a negative effect. The tribunal did reference but didn't really expand upon Lebanon and the impact of the minimum income requirement, and ultimately held that the sponsor's reluctance to go and live in Sri Lanka, while understandable, he suffered from health problems and also, of course, himself British and had ties to the country, but considered it was an attempt to compel the United Kingdom to give effect to his and his wife's choice of residence, which is paragraph 110. A further observation, which comes in at 104, was that, in effect, the deprivation for the children of their rights as British citizens was time bound. They found that since when they turn 18, they'd be entitled to move and reside in the UK if they chose. That was relevant to the infringement of their Article 8 rights. So moving on to the next slide, please. We have a case from the High Court in the Family Division, which is relevant when looking at the power that the High Court has to make a FGM protection order, and how that impacts on the Home Office's discharge of their immigration functions, in particular in relation to removal. So in this case, it involved a 10-year-old child whose parents were Sudanese. She had lived in the UK since she was 3, and her parents had ties to a region of Sudan where FGM was extremely prevalent, recorded at 98% of girls. Her father's whereabouts essentially were unknown. He was thought to be in Bahrain in a military prison, but despite UK government efforts, including from the embassy in Bahrain, they'd been unable to get any information in relation to him. So A's mother had come to the UK, had claimed asylum, and in part her claim was based on the risk of FGM to A. This was rejected by the Home Office and also on appeal, and the Home Office had proposed removal of A and her mother to Bahrain. So it was in that context that the court made an FGM protection order, and the order accepted the risk of FGM to A, and prohibited the mother from leaving the jurisdiction of England and Wales, but also prohibited the Secretary of State from removing, instructing, or encouraging any other person to remove A from the jurisdiction. A further hearing was held before the Administrative Court, and it was Mr. Justice Newton, at which the Secretary of State, who'd been joined as an intervener, submitted that it wasn't bound by the FGM protection order, and that the order should be discharged, having been made in excess of the bounds of the court's jurisdiction. So what then happened is the case was transferred to the President of the Family Division to answer 3 specific questions. Can we have the next slide, please? And those are summarised here, and that was the judgment of the President. And the first 2 are probably of most relevance for considering the case in the immigration context. The first is that the Family Court related to the Family Court's power to injunct the Secretary of State, and ruled by the President that there was no power for a Family Court to make an injunction pursuant to an FGM protection order against the Secretary of State to control the exercise of immigration and asylum functions. It was noted that the extent of the Family Court's jurisdiction extends only to respectfully inviting the Secretary of State to take the order into account. Secondly, this point considered the relevance of the first-tier tribunal's evaluation of risk to FGM, so the interplay between the first tier's determination and the High Court's function in assessing risk in the context of an order, and essentially held that rejecting the Secretary of State's submission that the first tier's decision should be a starting point, that the Family Court was conducting a different exercise, and it was under a duty, the court that was, to make its own assessment of matters on the balance of probability. We have the next slide, please. So the High Court then returned to conducting its task of assessing the risk of FGM to A, which includes an assessment of what are called contextual and specific factors. And the court's conclusion was pretty overwhelming in finding that FGM in the area was almost universal, and the court considered without hesitation that there was a high risk of FGM. I think this case is, of course, problematic because the Home Office's own fact sheets in relation to FGM protection orders state that they offer a legal mechanism to protect and safeguard victims and potential victims. But there's, of course, a question as to whether they are effective in circumstances where the Secretary of State is still determined to remove, the consequence of which would be placing a child at risk of FGM. So moving on to the third case, I'm slightly mindful of the time, but I will deal with all of these in a slightly longer paper. The third case, it is a positive news and potentially a good one to end on in relation to the Article 8 rights for children in foster care. I'm sorry, can we have the next slide? Thank you. So the case is Udin and the Secretary of State, and it looked at the correct approach to construing Article 8 for a child who had been in foster care, so the Article 8 relationship with a foster carer, when support had continued to be received when the child was now an adult. So in short, looking at a non-parental relationship, but a foster caring relationship, and also where the appellant had achieved majority, was over 18. And very briefly, the appellant was a Bangladeshi national, factual background disputed, but in short, he had said he had lived with his parents until the age of 6, but had been mistreated and was brought to the UK and abandoned by a woman. He was then treated as a trafficked child and placed in foster carer. He claimed asylum, which was refused. He was granted UASC leave. But then before the period of expiry, he applied for further leave, in part on the basis of family life with his foster carer. He relied on Kugathas, and a feature of the judgment is looking at the nature of that principle. And in short, the first tier tribunal rejected that. Case went on to the upper tribunal, again considered that family life didn't exist before the case moved to the Court of Appeal. And the Secretary of State was in effect arguing that there was a qualitative difference in the principle of relationships between birth families and those in foster care. They noted in particular that this was a contractual relationship. Foster carers were paid for providing the support that they did in a local authority's exercise of their statutory functions, and so the Secretary of State considered those relationships materially different. If you review the judgment, paragraphs 14 and 15 are interesting, I think, with broader application, looking at comments the upper tribunal had made about the expertise of the judge in the first tier below. The Court of Appeal supported, in effect, the tribunal is specialist judges, but noted that that was quite different from an implication that it's a factor to be considered on appeal, that experienced judges should not be expected to make mistakes. The Court of Appeal supported what was said in Kugathas, finding that it was a term of art, not a term of art, but a question of fact, and found that it could equally apply in a case in relation to a foster carer relationship. Could we have the next slide, please? So the Court of Appeal further held, endorsing Singh, the 2015 judgment, that there can be an existence of family life after a young person turns 18. So in short, held that one is really looking at the substance of Article 8 rights in the foster care context, rejecting the suggestion that it was a commercial relationship, and considered that really it's a fact-sensitive assessment and capable of success. So the appeal was allowed and returned to the upper tribunal. If we could have the next slide, please. This is, and the one after, sorry, I've zipped through. Thank you. So this is a case relating to children in care and whether a local authority has statutory powers to change the nationality of a child. I will deal with this very briefly. I mean, suffice to say that these were children who were under a care order, and after quite complicated proceedings where the local authority was seeking discharge of placement orders and parents were seeking discharge of care orders, the court was considering the parents' objection to their children being registered as British citizens. The court makes some useful observations. It's paragraph 23 in particular, about the momentous step, so a very different approach to the importance of nationality than we saw in the first case from the upper tribunal. They considered it was a matter of such significance that the local authority must tread with particular care and very seriously scrutinise the question of whether it was in a child's interest at that particular time to be registered. And the court ultimately concluded and declared that Section 33 of the Children Act 1989, so the provision for making a care order, didn't entitle a local authority to apply for British citizenship for these children in the face of parental opposition. And just to flag, there is relevant Home Office guidance, it's the registration of British citizen children that was published in April 2020, that acknowledges the local authority's responsibility to satisfy itself that a decision to register a child as British was in the child's best interest. So if we could go to the next slide, and I'll really leave this just as it stands. This is a case, FTH, in the Court of Appeal, which really brought to an end the chain of jurisprudence that has dealt with the closure of the Calais refugee camps and the expedited processes of Dublin 3 for the unaccompanied minors who were there. And really, the court upheld the fact that the process that the Home Office had adopted was procedurally unfair, but declined, in line with the judgment of the Court of Appeal earlier in 2018, the case of AM, declined to hold that it breached Article 8. If we could have the final slide, thank you very much. This is just to flag a policy document that's been published by the Home Office in April 2020 that relates to responsibilities of local authorities to children who are in their care to make applications under the EU settlement scheme. But I'll provide more detailed notes on that in our handout. Thank you very much, Simon.
Thank you, Antonia. We've had quite a few questions in the chat, and we've added an extra bonus of 5 minutes on top of the seminar. There's a lot there. 2020 was a busy year for immigration and asylum, and for some other reasons. We will circulate the PowerPoint and the written notes to everybody who attended the seminar, and I wish you a very good rest of your afternoon and evening, and hope to see you all again soon, and hopefully soon in maybe in only months, face to face. Bye-bye.